For pronouncement of judgment, item 12.
The writ petition is disposed of. The order of the Central Administrative Tribunal is interfered with. However, the respondent shall continue at ESICH hospital till 31st, and thereafter she will proceed for joining at her transferred place of post after availing joining time. Obliged.
Item 13.
The writ appeal is allowed. Consequently, the writ petition filed by the respondent number 1 stands dismissed.
Item 14.
The writ appeal stands disposed of. However, the order of the learned single judge is not interfered with. We have provided that in the event the central government takes a review exercise for changing the categories to the persons who have already got, the review exercise will also cover the respondents herein.
Item 15.
The writ appeal stands dismissed.
Adjournment request, if any, from item number 1 to 5.
Please, Your Excellency. I beg to mention item number 2. That is circulated adjournment slip.
Objection.
No,
No, my lord, no.
no.
Consent not, item number 2.
Yes.
Objection.
Acha, I'm sorry. Okay. Adjourn.
Obliged.
Yes,
May I please, your lordship? My lord, I beg to mention item number 4 and 5, my lord. Little accommodation after the vacation, my lord. My personal problem, my lord.
July.
My lord,
July.
With the request of learning council for the.
obliged. May I please, your lordship?
Adjournment request from item number 6 to 11.
May I please, Lordship? Lordship, I beg to mention item number 3, Lordship. My senior Mr. B has some personal difficulty. Matter may be adjourned for the day.
My lord, I have an objection, my lord. After admission of the matter, my lord, more than 4 times, my lord, adjournment.
Mm.
I always come prepared, my lord, what is the meaning of listing this matter? Simple matter, my lord. Matter taken up. Why they are taking the adjournment?
1962 date of birth.
Correction of date of birth.
इन्होंने बोला कि मेरे नहीं सर इंटरेस्टिंग नाइन में
ये फालतू को बोला है।
तो रिजेक्ट
वो टाइम नहीं मिलता है।
उसको सिंगल जज ने बोला स्टे नहीं
What's the problem?
Only for the day, Lordship.
For the day,
Hold on. Any date, Lordship.
next Tuesday. Otherwise, there is no stay.
Oh, stay, my lord. My lord, what happened, my lord? Always I come prepared, my lord. More than 5 times, my lord, they have taken continuously. That's why I'm, my lord, objecting it. No problem. Any harsh problem, sir? Maybe listed on, my lord, day after tomorrow.
Not day after tomorrow,
Day after tomorrow.
but Tuesday. Be
Yes,
prepared, we are not going to adjourn this matter.
Obliged, my lord.
Second.
May it please your lordships, may it please your lordships. Lordships, adjournment request was circulated with regards to item number 6 and item number 9.
Adjourn
Much obliged. Your Lord.
all the matters. August.
Where please, Lordship? I beg to mention item number 7, madam. I put a P.
Adjourn, August.
Hello, Lordship.
May it please your lordship, lordship, paying for listing of a matter, your lordship. What happened, lordship, is that
What about the matters listed today? All are adjourned. We are asking for listing the matter. Next week,
lordship, actually, there is some,
next week.
Lord, much obliged.
Daily list for hearing item 1.
May I please, your Lordship, Mr. Kiali is appearing through VC in some other court. Kindly pass over the matter. for the
Lordship,
panel.
I may seek some adjournment because I did not find him, so I did not take adjournment.
Fine.
Did not find him to take consent, Lordship, therefore I did not mention in the mention hours.
Now it is covered by the Supreme Court.
Yeah, yes, Lordship, that is,
Which one? Because judgment.
latest is 2016, 16, 14, and 16.
Where is that?
2000, Lordship, I have already.
2000 is gone
2000 is gone after that, 2000 in relation to the assessment year 62, 63. When this 89 amendment is not there.
Yes, Lordship.
After 89 amendments, the situation is different, sir.
assessment order ही नहीं
Lordship, assessment was not complete. I mean, when the assessment was started,
Even if the assessment order is not complete in view of the amendment made in section 147, it is always open for it.
even goes to the extent that 143 proceeding pending also 147 satisfied you point. Hmm. 13.
Just slowly on.
Lordship, a little adjournment for today, but.
Wednesday, next.
Much obliged.
Thursday. Next week.
Thursday, no.
Week starts from April, na? Wednesday.
Wednesday, no.
Sorry, Thursday, third.
Third.
Third of it.
Item 8,
हाँ, ये तो बाकी तो हमने डिस्कस कर दिया जीरो टू दैट तो प्राइवेट पार्टी डीलर के ऊपर हम इसे जितना बोलो तो
Lordship, item eight, some the payment is going on. Lordship.
Having settlement, what's the problem in that? Why to keep this matter pending?
Lordship, I am being led by senior counsel. He will appear what I have been told by my.
Call him, give me contact.
Yeah.
Call.
Yeah.
Call him. Since the similar challenge has already been dismissed by us. In relation to this very land.
Yes, Lordship, I'll call Passover for the time being.
Call him, the number is coming.
item number 10,
It is your lordship. In this matter, we are praying for some parity in pay, my lord, in the pay scale, my lord. We were working as source supervisors, grade 2 in the border roads organization, my lord. If my lord comes to the recruitment rules, my lord comes to page 40,
25% का जो wherever there is a direct recruitment and diploma is 5,000, 6,000, it's maybe one. But in the case, वो प्रोजेक्ट उन्होंने मारा अभी सर इन्होंने डिपार्टमेंट में ऊपर फिर उन्होंने यहाँ पे हाईकोर्ट में आने के टाइम सिंगल जज ने सुना सिंगल जज ने सुन के therefore appeal to recommended the announcement of provision and also recommended that others immediately place for carrying minimum pay of minimum qualification doesn't affect cycle. Single judge might leave the accordingly, the pay scale of the provincial holding is planned in terms of the middle class system. There will be disparity in the pay scale of the employees of spiritual. Does not follow the education qualification. Exactly, if the plan is that there will be more than one scale of paying the same provider to rate with the consider view as required by hospital. In that view, the method of care for enhancement of the pay scale is on the basis of education on the basis of recommendation of not be allowed to be able to the interpretation don't want to pay the to discuss. This reason to be other technical charge meeting. Mechanic diploma will look for if I had a in local. So proceeding with single person allowed to send up to the then all things postman you can to them. So in that way, it is the clear
yes, make use of. Lordship, if lordship comes to page 43, this is the recruitment rules of 1982. Yes, page 43, my lord, serial number 3 at the top, lordship will find overseer. Overseer, the qualifications are given on the right column, my lord. Essential, civil engineering diploma, licentiate or equivalent, or matriculate or equivalent possessing overseer certificate from ITC so-and-so with 1 year experience. The reason why I'm referring to overseer, my lord, we are not overseers. But in case of all the persons who are holding diploma in engineering, the Fifth Pay Commission had recommended them a pay scale of 5,000 to 8,000 unrevised. My lord, this is one example in which one of the essential qualifications is diploma in engineering or, my lord, matriculate with overseer certificate. So it is not necessarily that only a diploma in engineering will get this. Now, if lordship comes to, my lord, next page, page 44, this is charge mechanic towards the bottom of this page, page 44, serial number
Yes.
9. Similar, my lord, recognized 3 years diploma in mechanical automobile engineering or matriculate with so-and-so. My lord, may come to our one, my lord, at page 48.
Next page में एक चीज तो mechanical यहाँ पे डायरेक्ट रिक्रूटमेंट भी 20,000 ये तो क्या था इन लोग में भी 20,000 बट गवर्नमेंट का system few को आपने यहाँ page 47
Is 48, my lord. Then talk about supervisor store grade 2. Here the qualification, my lord. Essential diploma in material management or inventory control or storekeeping from recognized institution or diploma in mechanical automobile telecommunication engineering or equivalent or matriculate or equivalent past grade 1 course for storeman technical as laid out in defense service regulation qualification for soldiers. The recruitment portion, my lord, 25% by direct and, my lord, 75% by promotion. My lord, if my lord comes to column number 10 of this page, my lord, the bottom row, my lord.
Yes.
Column number 10, direct recruitment, 25% failing which by promotion and failing which by deputation transfer. Then promotion, 75% failing which from the army or posting transfer and failing which by direct. So essentially it's 25 to 75, my lord, but they are also interchangeable. Now, if my lord may come to the pay commission recommendations. At page 63, my lord.
Yes.
My lord, overseer, lordship had read towards the beginning, my lord. Higher pay scale has been demanded for the post of overseer civil and border roads organization on the ground that minimum qualification for the post is diploma in engineering. The post carries minimum direct recruitment qualification of diploma in engineering. These minimum qualifications have been prescribed in 1996. Fifth CPC in their report submitted in 1997 had recommended the scale of rupees 5,000 to 8,000 for all posts carrying minimum direct recruitment qualification of diploma in engineering. This recommendation was accepted. This post should consequently have been extended pay scale of 5,000 to 8,000 with effect from 1/1/96. This was, however, not done. The commission accordingly recommends that the post of overseer may be upgraded and merged with their promotional post of superintendent BR grade 2 present scale so-and-so and combined cadre extended the scale of rupees 5,000 to 8,000. Since commission has recommended merger of these scales, my lord, so-and-so. Now, lordship may come to the next one. Superintendent grade 2. The post of superintendent grade 2 in civil engineering and mechanical engineering cadre has been extended a pay scale of rupees 4,500 to 7,000, even though the minimum qualification of direct recruitment include diploma in engineering. Fifth CPC had recommended placement of all posts requiring minimum entry-level qualification for direct recruitment in diploma of engineering as rupees 5,000 to 8,000. Even though the recommendation was accepted by the government, it has not been extended in respect of this post because only some of the posts are filled through direct recruitment. This is not the correct interpretation of Fifth CPC recommendation, as per which all posts carrying minimum qualification of diploma in engineering for DR has to be placed in the scale of rupees 5,000 to 8,000. The post of superintendent grade 2 has an element of direct recruitment, minimum qualification for which is the diploma in engineering. The commission accordingly recommends that the post of superintendent grade 2 may be placed in pay band 2 of 8,700 to 34,800 along with pay of 4,200 corresponding to the pre-revised scale of 5,000 to 8,000 that is being merged with.
Nothing, the last line. Other posts. Similarly, they have been given only in the. They will only few posts.
Oh, my lord may come to the next page, page 65.
89.
So supervisor grade 1 and grade 2. Higher pay scales have been sought for store supervisor grade 1 and grade 2. The posts are presently in the pay scale of 5,000 to 8,000 and rupees 4,000 to 6,000 respectively. The next higher post above store supervisor is that of superintendent stores and is placed in the scale of rupees 5,500 to 9,000. Upgrading the pay scale of store supervisor grade 2 will disturb the existing hierarchical pattern. Insofar as the post of supervisor grade 1 is concerned, it will be placed in the higher scale as commission has recommended merger of the scales of 5,000 to 8,000, 5,500 to 9,000 and 6,500 to 10,500. The post of supervisor grade 1 and superintendent stores will therefore come to lie in identical scales. These posts should be merged. What I would be on, my lord, is that in respect of supervisor, overseer and superintendent, my lord, the commission accepted that since there is an element of direct recruitment, one of the qualifications of which is diploma in engineering, they ought to get the pay scale of 5,000 to 8,000. And they had also recommended merger of scales, which would disturb the hierarchical pattern in respect of those posts. But in the instant post in which we were working at that point of time, my lord, the supervisor store grade 2, my lord, this has not been recommended for the scale of 5,000 to 8,000, despite diploma in engineering being one of the qualifications. That was our case. Now, we had approached the authorities in the department, my lord. Initially, there were some communication to place this post along with some other posts, but ultimately they were negated. My lord, the learned single judge came to a finding, my lord. If my lord comes to the honorable single judge's findings, my lord, at page 136.
Para?
My lord. Para 6 starts at page 135, my lord. Relevant portion is at page 136.
Yes.
My lord. My lord, may come. I'll read just from the middle of the sentence at 136, my lord. The first line, middle of the. It appears that the essential qualification for appointment to the my
Which line? Fourth, fifth, sixth?
my lord may come. This my lord may come from the top of the page itself, my lord.
It appears.
It appears, my lord, that the essential qualification for appointment to the post of supervisor stores grade 2, apart from diploma in mechanical, automobile, telecommunication, engineering, there are other sets of qualifications provided, namely diploma in material management or inventory control or stores keeping from recognized institution or matriculate or equivalent past class 1 course for storeman technical as laid down in defense service regulations, qualification regulation for soldiers, which means and would go to show that the cadre of supervisor stores grade 2, other than persons with diploma in mechanical, automobile, telecommunication, engineering, there will be hosts of other employees who may not have diploma in engineering, but may have other qualifications prescribed under the recruitment rules and entered into the cadre of supervisor stores grade 2 by means of either direct recruitment or by promotion from the lower grade. The supervisor stores grade 2 therefore would comprise of persons with varied education qualifications, and accordingly, if the pay scale of supervisor stores grade 2 in holding diploma in engineering are enhanced in terms of recommendations of the 6th Central Pay Commission, as contended by the petitioners, there will be disparity in pay scale of other employees of supervisor stores grade 2 who does not possess the education qualification of diploma in engineering. Therefore,
डिप्लोमा है इन लोगों ने मेट्रिकुलेशन प्लस सर्टिफिकेट प्लस फर्स्ट क्लास 5 years सर्विस किया becomes equivalent तो उनको भी ये extend
Yes.
Therefore, if the prayer made by the petitioner is allowed, there will be more than one scale of pay of the same cadre in the supervisor source grade 2, which in the considered view of this court would not be permissible. In that view of the matter, prayer made by the petitioner for enhancement of the pay scale in the post of supervisor source grade 2 on the basis of the education qualification of diploma in engineering alone, on the basis of the
Before my case, I had four. Maybe like Vishwakarma. That mechanic. Already felt that. इन लोगों ने वो रिलाई नहीं किया यहाँ पे रिलाई नहीं किया
Yes.
My lord, the reasoning in my humble submission, my lord, that there will be more than one scale of pay basing on the qualification of the employees. In my humble submission, my lord, that would be incorrect, my lord. My lord, I understand, my lord, that fixation of pay, my lord, is not within the ambit of the court, my lord. But when there is a discrimination, my lord, on the basis of, my lord, qualification, some have been allowed, some have not been allowed on the very same basis, my lord. That, in my humble submission, requires interference by your lordships, my lord. That's why, my lord, what we are praying for is that we will not get the salary for that. But what we are on, my lord, is the pay fixation for that period. Because ultimately, thereafter, we have been promoted. We have been promoted to supervisor source. Yes, during that period for the fixation. So, my lord, my humble submission, my lord, there cannot be a discrimination on the basis of qualification.
May please your lordship. He has made already in their submission that as per 1982 recruitment rule, what are the qualification? At the time of entry level, the qualification was not that appellant point, my lord. At the time of entry level, that was on 6-pay commission, they have come into force, my lord. You kindly see, my lord, page number 144, my lord. In my affidavit in opposition, my lord. 144.
Yes.
This is the qualification, that second paragraph, that with regards to made in paragraph A1 of the writ appeal, the assignment begs to state that in exercise power conferred by the provision of Article 309, considering the respondent had made a general reserve engineering force group C and group D recruitment rule 1982. According to the state recruitment rule 1982, the post of supervisor store grade 2 was to be filled up by the 25% by the direct recruitment and 75% by the promotion. The essential qualification recruitment for the direct recruitment to the state post is, and these are the qualification, my lord. Then, my lord,
That is the only basis on which the learned single judges.
Yes, my lord.
Since we can't, there should be a disparity.
yes, my lord.
amongst,
Disparity-
But
that
that
is-
is not the case because the persons who are matriculate or equivalent pass,
Yes, my lord.
class 1 selection, so and so, they are also entitled for the same grade.
In my lord, there 6-pay commission, kindly see page number 146, my lord.
Yeah.
Of 146, relevant by 148, my lord, store supervisor grade 1, grade 2, as per 6-pay commission 7.39.27, my lord, clause, page number 148.
Yeah.
Higher pay scale have been sought for the post of store supervisor grade 1 and grade 2. The posts are presently in pay scale of 5,000 to 8,000 and 4,000 to 6,000. The next higher pay scale store supervisor is the superintendent store and is the place in the pay scale of 5,500 to 9. Upgrading the pay scale of the store supervisor, the grade 2 will disturb and exist in hierarchical pattern. That is the, even though upgraded the but they have observed that upgrading the pay scale of store supervisor grade 2 will disturb the existing hierarchical pattern, my lord. That is the observation. And on the basis of observation, my lord, Annexure D, page 166, my lord.
But ultimately, what they have said, the post of the supervisor, superintendent stores will therefore come lie in identical scale.
Yes. But the observation of the border road and development, kindly see, my lord, page number 166, Annexure C, my lord. and 66.
Yes.
Kindly see, madam, our relevant, our portion is page, para second part, my lord, B, 2B, my lord. As per existing RRS minimum entry level qualification for the post of superintendent store grade 2 is diploma, mechanical, automobile, telecom, material management undergraduate with 2-year experience of engineering store are also eligible for recruitment to the post of supervisor store grade 2. Moreover, only 25% post of the total authorization are filled through the direct recruitment and remaining 75% are filled up through the departmental promotion. As the entry level qualification to the post of supervisor store grade 2 is not diploma engineer, hence the post do not fulfill the recruitment for the grant of higher pay scale grade pay of the 4,200, my lord. This is the observation that is the report of my lord, Border Road Development Board, my lord. So on the basis of that, they have, since their entry level qualification to the post of supervisor grade is not diploma engineer, so they are not entitled for the grade.
Same name का आपका overseer को भी अगर देखें it's equivalent.
And my lord, 6 pay commission itself observed in one of the paragraph, my lord, upgrading the pay scale to the score supervisor grade 2 will disturb the existing hierarchical pattern, my lord. That is that, my lord. On observation of that, my lord, the Border Road Organization has made a report that is page 167, my lord. Because their entry level and the entry level that is that as the entry level qualification to the post of supervisor store grade 2 is not a diploma engineer, so they are not entitled for the upgraded scale of upgradation, my lord.
Yes.
And my lord, line at the lower court rightly observed that in para number, in the last para, my lord. Last para from the middle, my lord.
Yes.
The supervisor store grade 2 therefore would be comprised of the person with the varied educational qualification, and accordingly, if the pay scale of the supervisor store grade 2 holding diploma engineer are enhanced in terms of the recommendation of the 6th pay commission as contended by the petitioner, there will be disparity in the pay scale of the other employee of the supervisor store grade 2 who does not possess the educational qualification of the diploma in engineer. That means that entry level qualification, my lord, that is observed by the observed by Border Roads observed by Lanet Singuljas, and on the basis of my love annexure C of my affidavit in opposition, that is Border Road Development Board report, my love. That is annexure C, case 166, my lord. So my lord, since their entry level is not, so they are not entitled for upgradation of that, my lord.
That's all?
Yes, my
Deeply oppressed.
Ask the plan.
Mr. Nair,
Sorry.
there are two decisions of this court. One is Vishwakarma pertaining to charge mechanic
Yes, ma'am.
and Pramod Kumar.
Yes,
Can you
ma'am.
get a copy of those
Of course, ma'am.
today itself?
Man.
11.
Item 11.
My lord, there is
Lord, I'm appearing for the petitioner in the appellant in item 11,
Yes.
my lord. My lord, on the last date, I understand my lord felt that the amount pertaining to the matter is only 68,000 rupees and this appeal should not be kept pending. Can my lord hear me?
Yes.
Yes, my lord, I'm saying I understand that what fell from my lord on the last date was that since the amount is only 68,000 rupees, this appeal it's not something the appeal should be continued. My lord, the problem is this is a government body. There are about 35 employees. Matters are pending in Delhi High Court.
How it is?
So it's a question of law, my lord.
Question
My lord,
of
I'm
law,
just pointing out why we are pursuing this.
We'll keep it open for you to argue it in another matter. In 68,000, we are not going to interfere in this matter, sir. For only for 68,000 and the poor employees, you are arresting them only for rupees 68,000. What is
Right, my
this?
lord.
And you have contested the matter to a single judge, and now you are contesting here and the advocates are engaged, senior advocates are being engaged. What is this, sir? How much money you are spending on this, saving this 68,000 rupees?
My lord, like I pointed out, my lord, I understand what is falling from my lord, but it is not about
Please try to
68,000. We are a,
Right of
yes, my
the,
lord.
the poor people has to approach here, the court engage a counsel and then for only for 68,000. What he will get ultimately in his hand?
Right, my lord. My lord, in fact, has been released the 68,000 already by the writ court, which was deposited when we filed the petition.
Then it's okay. If you deposit it, then we'll keep it open. The question of law in
Yes, my lord.
any other appropriate for adjudication, we are not inclined to. At this stage.
My lord, my only problem is I cannot give consent for it, but my lord may pass appropriate orders. I have no,
We will pass an order.
yes, yes, my
Thank
lord.
you.
Much obliged, my lord.
Close for orders.
Timing item 8.
Yes, sir.
May I please? Look, I was not aware about the listing of this matter. There was a discussion with the Honorable Chief Minister, and they have given an alternative land for shifting. I think there is going to be a memorandum of agreement. I don't know the exact stage, so your lordship will have it on Friday or next
So in
Monday.
fact, a similar challenge to these acquisition proceedings.
No,
we have
no,
already-
I know, but this has nothing to do with that. We were allotted, government allotted the land long time ago, therefore we are not unauthorized occupants.
No.
But your lordship can have it. Your lordship can have it on next, this coming Friday. We'll take instruction. If there is an agreement already signed, I'll bring it and your lordship can note that. These are 300 people are being coached, affiliated to All India Tennis
The
Association.
decision is already taken. We'll take note of this, that this decision is already taken.
I have not seen it myself.
You just see that.
Yes.
Item
Memorandum of agreement only. No, I know, Milord, this was the idea that was given, but they said that we'll have a memorandum agreement, so I will find
Agenda
out.
for 4 weeks. Yes, sir.
Huh.
Agenda.
You're also gonna have it next Friday, I have no problem, I will take the.
So I will adjourn it for 4 weeks. In the meantime, the memorandum.
As your lordship pleases. If it is already done, we'll file it.
Adjourn for 4 weeks.
Good. Right.
Any adjournment request?
May it please your lordships. Lordships, adjournment requests were circulated with regards to item numbers 5 to 7, specifically item number 7. May the matter be adjourned, your lordships.
Other side is agree.
They have
Adjourn.
much obliged. Your lordship.
The next assembled. Yes.
Daily list for orders, item 1.
Hello, this is a review petition. Hello, we are not in receipt of this acknowledgement forms by the respondents. Now we have received, we will be filing the affidavits, just the affidavits.
Notices have been served upon them.
Yes, my lords. They have acknowledged, my lords. These receipts will bring out on record, my lords. All the respondents have received, my lords.
reviewing this order?
What had happened, madam? There was a miscommunication between the department and the council that very day. And there was a statement made that we are never going to issue any kind of settlement in that area in question, which was the subject matter of the PIL. That was the mistake, my lord. That has gone into in the order, my lords.
So now there is a policy decision to give this mining lease.
Yes, my lords. There was always a policy decision, my lords.
So how ultimately the PIL was dismissed?
My lords, my lords will kindly allow this review petition, my lord, and adjudicate the PIL on merits, my lords.
Nothing. No case for review is made.
No, my lords, that statement was made, my lord. It was never communicated, my lord. It was due to
Whenever-
misunderstanding, my lords.
Whenever it has come to this notice, after all this 3 years period is there already. What remains in this?
There was no such kind of communication, my lords. But because there was already a policy decision, my lord, that
No
area,
such type of communication, your statement of the advocate is there, what to do with it?
my lord, that was due to miscommunication, my lords.
Miscommunication, then it's okay, miscommunication, that is not a ground of review, sir.
That is our fault, my lord. That area needs to be settled, my lord. It's a huge, it gives us huge amount of, my lord, it feeds the exchequer also, my lord.
Learned concept for the
Lordship is,
review petitioner has stated that the notices of the review petition has already been served upon
respondent 1, 2, 3 both. All three of them.
1 to 3. Full stop. He has submitted that the proofs regarding the service of notice upon the respondent number 3 is already placed on record. Full stop. In such circumstances, we deem it appropriate. We are of the view that the notice of review petition has already been served upon the contesting respondents. Full stop. This review petition is filed by the petitioner seeking review of the order dated 18/2/2022 passed in PIL petition number 130/2015, which was closed, taking into consideration the statement made on behalf of the learned standing counsel for the forest department that a policy decision has been taken not to give mining lease of unit first Channi Ghat for the present. Full stop. Learned counsel for the review petitioner has submitted that as a matter of fact, no such policy decision was there, and it was and the statement was given by the state council by the council for the forest department on account of some misinformation. Full stop. Be that as it may be, we don't find any, we don't find this reason to review the order passed by this court, hence this
Prayer was, my lord,
petition is dismissed.
my lord, to bring back the PIL alive and adjudicate the issues, my lord. Otherwise, we lose exchequer losers, my lord.
Next. You don't
How less, my lord?
Item number 2.
This is after notice review petition of your lordship's judgment and order dated 9/5/2023.
9/5/2023.
Short point, my lord, is this, my lord, and the error apparent which I'll place, my lord. The review petitioners, my lord.
Lordship, before my senior starts, Lordship, Lordship, in this case, Lordship, Mr. K. Chaudhary is leading, Lordship. Let him part be on the next date, Lordship.
Settle amongst yourself. It is not between the court and all. If he is objecting, we are going to hear this petition, or otherwise settle it yourself. Yes.
My lord. The review petitioners, my lords, were appointed on ad hoc basis originally in between 94 and 96. Now, my lords, this is an inter se seniority issue. There was a selection process.
Page 41.
There was a selection process, my lords.
41.
Their regularization was by cabinet decision, relaxing the process. That's why it was a part of the rules. This morning, appointed by processing. It says seniority will be as per the names in the syllabus. Since they were not appointed by that, there's no question of the name in the syllabus. They were subsequently regularized by any cabinet decision. Cabinet decision is not placed before us, which will nor does it have they placed any material to say how their seniority doesn't seniority is to be determined. So this board will follow the rules. Because the rules say seniority as per name. So since the name of the respondent was put there, their claim for seniority was given. While saying that this particular observation is given by this court. Now, according to them, they say that it is not a regularization in an exception over the rules. Rules provide for relaxation. The cabinet undertook that power and relax the requirement. So perhaps for this observation, they are filing it. They will not change, but perhaps they feel that further promotion or something, this may be used against them. That's again urging the appeal also. That is the ground to be urged the appeal. It doesn't change the, it doesn't change. You are agreed by this observation in para 20.
20 and 29 also, my lords. 29 because it would, my lords, Mukul Saikia, my lords, the judgment which had upheld the regularization of the review petitioners, two things flow out of that, my lords. One, that the regularization was by invoking the relaxation power under the service rule order. Second, more importantly, my lords, this regularization is against promotion quota vacancies. So for Rule 10 to apply, you have to be of the same common stream. Here there is, my lords, the inter se seniority is between direct recruits, and we are, because of Mukul Saikia, will have to be treated as promotees. So there is no common select list. Merely because I participated in a selection process where I was unsuccessful would not make me a direct recruit, because Mukul Saikia has categorically.
How does Mukul Saikia, how can you rely on Mukul Saikia to submit that judgment had rendered a finding that you will be senior?
Not senior. What the judgment says is this, my lords. One is para 20, my lord, that's, my lords, an error apparent because the judgment, if I may place Mukul Saikia, my lords, Mukul Saikia, your lordship, because that is the judgment which had upheld my regularization, and some observation.
It did not upheld your regularization. That's
It
the
had, my
finding.
lord, it had upheld my
That's the
regularization.
finding. The challenge made by the other side.
Other
before the
side,
apex court.
my lord, Mukul Saikia was a case, my lord, because the advertisement was 27 vacancies. Now the select list was 64. I didn't find place in the select list. Original advertisement, my lord, is 27 vacancies. Select list was 64. People who were below 27 moved the courts, claiming that now against future vacancies, in vacancies below 27, they should be accommodated. Also, they assailed the cabinet memo by which I was, my lords, the policy by which I was regularized, the whole review petitioner. So two things arose. One, whether they have a right for appointment against excess vacancies. Secondly, whether the regularization of the review petitioners was valid in law. So, my lords, the court said, so far as their right is concerned, they are under direct recruit quota. The moment 27 vacancies are exhausted, they don't have any right to claim any further appointment because the notified vacancies stood exhausted. More importantly, the court says You being a claimant to direct recruit quota have no locus standi to question the regularization of the review petitioners
Correct.
who were regularized by invoking clause 11 under the promotion quota.
Correct.
My lords, if I may place Mukul Saikia. And that is why, my lords, Rule 10 may not apply. My lord has Mukul Saikia, 2009, 1 SCC 386.
Yes.
Para 3, my lord, briefly, the facts are noted that may your lordship may just have a. May I lord
No,
with your
but,
lordship's permission?
Mukul Saikia and party are not,
Not before.
not before this court.
No, no, my lord.
So therefore, the issue before this court is inter se seniority.
Mukul Saikia was aggrieved that you are not making appointment beyond 27 appointees, but you are regularizing other
right.
people who are
That has been
unsuccessful.
turned out.
That is why, my lords, the Mukul Saikia, the for regularization was challenged. Ki you are now regularizing people who are unsuccessful.
No. Subject to correction.
Right.
My reading of Mukul Saikia is the challenge made that beyond the 27 posts, whatever has been appointed, you can't make regularization to those people.
No, they made that.
Right.
It
Which
is
was-
intertwined that
which
they
was-
challenged
which
you
was
are going
turned
on regularizing people who are unsuccessful, not making appointment who are in the select list
Correct.
beyond 27.
Right. So that was
And
turned out.
both were repaired. My regularization was an issue and it was upheld by the Honorable
So
Supreme.
was-
My
so
lord,
was-
my lord, may I place this judgment,
Yes,
my
please.
lord?
Yes,
Para 3, just,
show us the finding where the
my lord, para
held
4,
your regularization.
my lord, then I can show your lordship straight away to the findings. First, if your lordship sees where I came, para 18, this is where we come into being because those promotion quota vacancies. The contesting respondent stated that in the year 96-97, there were a total number of 45 vacant posts of CDPO and allied cadre in the.
No, Mr. Counsel, we are trying to understand where is the finding of the judgment that your appointments or regularizations have been specifically upheld.
My lords, that paragraph, your lordship may just straight away come to 43 at 397.
Yes.
Somewhere I may read my lords, the whole paragraph 43. Annexure 1 attached to the service order contains class of post so and so. I can skip, my lords. Column 6 of Annexure 1 prescribes that 40% of posts of CDPO have to be filled by promotion from amongst persons who have rendered 10 years of continuous service in the cadre of ACDPO, Assistant Superintendent, Homes and Allied cadre, and 60% by direct recruit. The private respondents, no doubt, were appointed on ad hoc basis, and admittedly, they have not completed 10 years of continuous service in the cadre of ACDPO. But the state of Assam, with the approval of the cabinet, decided to regularize the services of the appellant as a special case by giving relaxation under clause 11 of the service order. Therefore, the decision of the cabinet pursuant whereof the state government issued the notification cannot be said to be arbitrary and irrational. The appellant fall in a different category and they have no enforceable right to challenge the regularization of the private respondent who have been regularized against vacancies made for promotional quota. In their writ petition, they have prayed for their appointment because their names were included in the select list by APSC against direct quota. The government appointed 27 persons in order of merit out of the select list prepared by the APSC. As such, the appellant selectees cannot claim appointment as a matter of right in excess of the advertised vacancies. It is settled law that This is, my lords, it clearly holds two things, my lord. They don't have a right to appointment beyond the notified vacancies. My regularization as a special case against promotion quota is valid.
That is not here. Somebody telling me there. Very much done. Now, questioning some seniority. They say that since our regularization was upheld, we were there in service well prior to the respondent.
That's all.
Para 40, my lord.
You are now trying to re-urge the matter.
No, I quite see, my lord. I know the scope of review is very limited, my
limited.
lord.
You are-
What I don't have to go to paragraph after paragraph, but
Even if we alter the tenor of para 20, this last
It-
line, then also it doesn't
no, the question now,
ultimately
my lords, is whether your
change
lordship's
the
interpretation
finding.
in paragraph 929 that the seniority should be reckoned from the date of the select list in view of rule 10 is the issue which is my lord.
We have already rendered. Now, if we have to reopen this issue, and that
No, my
amounts
lord,
to
whether
re-hearing
my-
the matter.
Quite see, my lord, what is falling from your lordship. Your lordship, I am putting the case in a narrow campus, my lord.
You
Compass.
simply show us
My-
error apparent on the face of.
My
the
lord,
report.
error apparent. Your lordship will appreciate two things. I don't want to go to paragraph on the paragraph.
Yeah.
Two things emerge from this judgment. One, my lord, that I was regularized by invoking the relaxation clause as a special case. Secondly, what is important is that my regularization is against promotion quota. The 60-40, I am merely because I participated in the process, I cannot be treated as a direct recruit. My regularization took place against those 40% quota for promotion quota. That two things emerge, my lords, from this judgment. Yeah. If that be so, then my lords, your lordship, the two paragraphs of your lordship's judgment, which I may place, my lord,
The number 20 and
29, my lords, and the clause 10 of the rules, my lord. I quite see, my lord, the review
Where is the error
jurisdiction.
apparent?
Error
Where is
what
the
your
error
lord-
apparent?
Because, my lords, review your lordships have held
You
sometimes
may
misconception of fact and law because
you
it is
may
sufficient
disagree with
reason,
you
my
may
lord.
disagree
Review
with the
scope-
interpretation.
It all depends where, how much width your lordships wants to give. Reviews jurisdiction, my lords, is elastic.
We frankly don't want to give any width
That's
unless you
true,
point
but
out the
courts have held, my
error
lord,
apparent.
error apparent or misconception of fact and law, my lords.
we will pass
My
it on.
lords, let me try and persuade your lordship.
We'll pass it on.
My lords, two paragraphs before your lordship and the rules.
Yeah.
The judgment, my lords, the division bench judgment, para 20.
Yes,
My lords, in the present proceeding, it is not in dispute that the appellants had appeared in the selection process but were unsuccessful. The government at the relevant point of time, by way of cabinet decision, resolved to regularize the service of the appellant and subsequently by notification dated so and so, the service of the appellant were regularized. Although issue regarding the manner of selection is not before us, but the fact remains that the process adopted in favor of the appellant for regularization of their services is not prescribed under the service order. That,
though it was prescribed in the service.
that your lordship has seen.
Next,
But that doesn't take me anywhere, my lords. Para 29 is the issue, my lord.
yes,
Considering the entire matter, and in view of the fact that the appointment of private respondent number 1 to 19 were conducted through a process prescribed under the service order, it must be held that they were regularly appointed as per procedure prescribed under the 94 Service Order Regulation. The appellant, on the other hand, were regularized in their service as a special case which is recorded in the judgment by the Apex Court in Mukul Saikia. While regularization of the appellant cannot be questioned in view of the decision rendered in Mukul Saikia, the fact remains that the service order was not under consideration, which may also not be correct, my lord. All these clauses were very much into consideration, taken into consideration from paragraph 40 onwards.
Okay.
As it stands today, clause 10 of the service order categorically lays down the procedure that the seniority is to be based on the names that appear in the select list. This is, my lord, clause 10.
This is wrong.
This, your lordship would just have a look
This
at.
finding is incorrect.
Incorrect, because.
Check it in the appeal.
No, your lordship.
Incorrect finding is always not open.
No, it is on the, my lord. Your lordship is right. I am only, my lord, making an attempt, my lord. Why I am saying it is law.
Right to say that the judgment is not in accordance with law or incorrect.
No,
but
I am
then
not
the
saying, my
appeal
lord.
is-
My lord,
Challenge it by your finding.
your
and
lordship is absolutely
appeal
right.
also.
I am saying it is erroneous because, my lords, the question of a select list and the inter se names therein would come into the picture provided they are of a common stream. Here, it's an inter se seniority between direct recruits who were in the select list, and now we'll have to be treated as promotees merely because I participated in that process, but was regularized under a different quota. Therefore, there is no common select list. That is the short point, my lords. My lords.
Will pass it.
One judgment for my lords, whatever my lords, review, the scope of review.
Latest judgment, Sanjay Kumar.
It is one point I was thinking would be.
Latest Sanjay Kumar judgment 2020.
That is one, just one point, my lord, is also says that if it's a misconception of fact and law, your lordship may consider.
We'll consider that. Consider your submission.
We'll consider your submission.
We'll consider your submission.
I know, my lord. I quite see, my lord, the review jurisdiction is limited, but I was trying, if it's within the narrow scope, my lord.
Pass an order. sir.
My lord, deeply obliged. This judgment only thing, my lord, so that my submission, para 15. Because, my lord, ultimately, my lords, my regularization is November 2000. They are 2001-2. That your lordship will bear in mind. So normally, if there is absence, the date of entry is, the government took the view that date of entry is the relevant, my lord. No, my lord, there are judgments both ways, my lord.
Which-
Consent, my lord, deeply obliged. My lord, I am not going into the other judgment because your lordship indicated the narrow scope.
We'll pass orders.
I am deeply obliged, my lord.
Item number 3.
Made to your law. In this case, the petitioners who are now holding the post of assistant engineer, they were, my lord, appointed in the year 1992. And from 1996 onwards, they were officiating in the rank of assistant engineer. My lord, I have prepared a long list of dates because there is a checkered history. They have approached some report again and again. And my lord, the review petition we have filed basically on the
Error
ground.
apparent on the face of the record.
My lord,
Shows.
my lord,
That's the only thing.
my lord, I'm just showing two things, my lord. I have given a list of dates.
So list
Serious-
of date, if we are going by all these list
No,
of
but
date,
not-
it amounts to re-hearing on the
No,
matter. Error apparent on the
not
face of the
necessary.
record.
What has
That's
happened,
all.
my lord? At one point of time, that is in 2013, we were granted
Which which finding of the judgment
Right.
troubles you that it is an error apparent on the face of the
Well,
record? Sure.
Well, I'm coming to that. Before that, I'm just giving, instead of taking a lot of to various paragraphs, well, I'm just giving the background in which this submission I'll be making. 2013, my lord, they were ultimately given the promotion through a DPC, regular promotion, but with effect from the date of DPC in the same year. And thereafter, my lord, we approached the Honorable Court saying that no, we were officiating from 1996, kindly grant us. This Honorable Court, my lord, on single judge, passed an order holding very clearly that from the date of officiating promotion to the rank of AE, our seniority should be counted. Recon. Thereafter, my lord, but ultimately this Honorable Court directed the government to consider. But while considering, they have rejected our prayer. Then we approach this Honorable Court again. Now, unfortunately, my lord, the same judge holds completely a different view.
That's
we-
when you have filed the appeal.
My lord, then, my lord, then our submission was that this judgment amounts to review of the earlier judgment, which the state never preferred and never sought for any review. So that was, writ petition was dismissed, holding that no, now your officiating promotion period cannot be counted towards your seniority. Then we preferred a writ appeal, and in the writ appeal, there is a reference of an earlier judgment, of course, in our case only, saying that no, you will be affecting many of your juniors if we give you retrospective promotion. And I am saying that, subject to your lordship's consideration, there is an error apparent. And I am not saying that by affecting our seniors, we should be given retrospective promotion. But in terms of the Supreme Court judgment of 1990 that directly took case, if without affecting any of my seniors, we can be given a retrospective promotion.
So ultimately, you can very well say that as per you, this
Right.
judgment is not laying down correct proposition of law in the facts and circumstances of the case. Therefore, it's a matter of challenge you appeal.
I'm not
the
saying,
case of.
I'm not saying that. What I'm saying is, my lord, this Supreme Court did not consider that aspect of the matter. That without affecting senior, whether we can be given retrospective promotion from a date from which we do not affect any of our seniors in the rank of J. This much only. Can that really minimum relief be given to us? In that case, we do not affect anybody.
That's all.
I know.
Close for all.
Deeply.
Item 4.
Yes.
Lordship. Kitab to the end. Lordship, the matter relates to whether the OP was entitled to pension or not. Now, Lordship, this rule was not brought into the notice of your Lordship when the matter was decided.
How the judgment is
But
erroneous.
Lordship 3A says that his earlier service is not a civil post. So whether, and Rule 6 says Grameen Duxable shall not be entitled to any pension. In view of that, whether he could be given pension, Lordship. Rule 3A, Lordship may kindly see 5. A Sebak shall be outside the civil service of the union, and a Sebak shall not claim to at par with the central government employee. 6. And Rule 6 says pension, GDS gratuity. The Grameen Duxable shall not be entitled to any pension. In view of that, whether his past service could have been counted.
The rules have not been prepared.
And pension could have been given to him, Lordship.
Which rule was not referred to?
This rule was not brought, not brought into notice of your Lordship.
Which rule?
This Grameen Duxable rules.
How this is applicable in this?
His earlier appointment was a extra departmental assistant, which is now
This was taken into consideration by the CAT.
This was not placed in before CAT also, but CAT rejected. CAT rejected his prayer. He preferred a writ petition that was allowed. This aspect was neither brought before the CAT nor before the division bench also, Lordship.
Notice returnable 6 weeks.
Deeply obliged.
Does this review petition as and when this bench is next assembled?